Land conflict continues to dominate headlines across Uganda, from village boundaries to city plots, and for many families, these disputes bring violence, loss of property, and long-term economic suffering. With the growing population, unresolved historical claims, and complex land tenure systems, clashes over land remain some of the country's most explosive disputes. For years, leaders at both local and national levels have stepped in to try to resolve these tensions. Among the most outspoken has been the Minister of State for Land, Dr. Mayanja, who has repeatedly blamed the Milo land tenure system and what he calls the Mengo establishment for many of Uganda's long-standing problems. Mayanja has made bold moves, ordering arrests of people involved in illegal evictions, directing that displaced residents return to their land, and attempting to nullify land titles he believes were fraudulently obtained. But now, a major ruling from the High Court in Kampala has drawn a clear line along the minister's powers. High Court Judge Joyce Kavuma has ruled that the Minister of Lands does not have the legal authority to order the cancellation of any land title. According to Section 88 of the Land Act, the power lies exclusively with the Registrar of Titles and only under strictly defined circumstances. The registrar may cancel a title only if it was issued in error, contains an illegal endorsement, was wrongfully obtained, or is being wrongfully retained. And before any cancellation can happen, the law requires a public hearing that meets the standards of natural justice. This ruling follows a challenge filed by Misbahu Muslim Community Limited, whose land title for property on Naguru Drive had been targeted for cancellation following directives issued by Minister Mayanja. The applicants asked the court to declare the minister's actions illegal, irrational, and an abuse of office. In her ruling, Justice Kavuma emphasized that any directive from a minister, especially one that bypasses established legal procedure, has no force of law and cannot bind the Registrar of Titles. The Attorney General argued that Mayanja did not directly order cancellations, but had simply written to a senior presidential advisor to follow on the matter. The court agreed that since no official action had been taken, the application for judicial review was premature. However, the judge stressed that even if the minister's directives had been implemented, they would still be illegal because the minister has no powers to cancel the land titles outside the procedures set by the Land Act. Justice Kavuma further noted that there was no communication at all, not from the minister nor from the senior presidential advisor to the Registrar of Titles instructing any action on the disputed land. Despite this ruling, Minister Mayanja is not the first to exercise such powers. Former ministers Ida Nantaba and Persis Namuganza were also known for issuing directives to cancel land titles, especially those involving disputes between landlords and vibanja holders. As Uganda continues to grapple with widespread land disputes, the question remains, what is the lasting solution, and how can leaders ensure that justice is served while protecting vulnerable communities? Uganda Radio Network will keep tracking developments in this case and will continue reporting on a broader land crisis facing the country. Story compiled by Beka Bate Lule, Uganda Radio Network, Kampala.